first case to come before the court today is State of Ohio v. Jahlin Suggs. Each party will have up to 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know, as I'll be keeping track of the time, and I'll try to alert you when you're coming close to your rebuttal time. The arguments are being recorded. When you present your argument, please introduce yourselves, stay behind the podium, remain there, keep your voices up. You should not use the names of children or victims or minors during your argument. You can refer to those folks by initials or terms like the child. We have read your brief, so we're ready to proceed when you are, and I would just ask, appellant, would you like to reserve time for rebuttal?
Thank you, Your Honor. May it please the court, yes, we'd like to reserve 5 minutes for rebuttal.
Okay, very well, then you may begin when you are ready.
Thank you, Your Honor. May it please the court, my name is Attorney Wesley Buchanan. I have the privilege of representing Jahlin Suggs, the appellant in this matter. As indicated, we'll reserve 5 minutes for rebuttal. Jahlin went to trial on a myriad of offenses of serious nature involving the discharge of firearms, and he was convicted and sentenced to 8 to 10 and a half years in prison. At trial, the evidence did include that there was a mask, there was shooting, and that Jahlin was wearing body armor. However, in addition, Jahlin will also indicate to the court that he was the first to go to trial of those people that were identified to be involved. As the court did state, as far as the victims are concerned, the jury did not hear all the evidence at Jahlin's trial. The trial court did exclude the proffer made by Jahlin of exhibits J, K, and L. And you know, as far as Jahlin's case is concerned, they are very, very important because Exhibit J was the certified conviction of the juvenile co-defendant, which is referred to by initials in the brief, and I believe that was Jahlin's brother. And that includes the same set of facts that were involved here. The court excluded that based upon relevancy, and as this court is well aware, relevancy is a very low standard. Any tendency to make any fact an issue relevant or probative, or excuse me, more or less probable. Here, while Jahlin was convicted as a complicitor, he would have the ability to point at his trial the person who actually may have done the shooting, even though the law does not distinguish between the person who committed the offense and the person who was complicit in the offense. It still nonetheless would be relevant to his case. So that's very important, and the court did exclude that. So Jahlin would indicate that's an abuse of discretion, as this court has to review evidentiary matters as far as abuse of discretion, unless the trial court makes an error of law, which is an abuse of discretion. In addition, exhibits K and L were one of the residents of the home, and this is very, very relevant because there were 9mm shell casings found outside the home, and that's found located in transcript at 280. The person, again, we won't, pursuant to this court's request, we're not going to name the person, but this person did have a criminal history of carrying a 9mm handgun, and he was not legally permitted to carry a handgun. And again, the offense of improperly discharging a firearm into a habitation under 2923-161 starts with the without privilege to do so. And if there was a person who has a 9mm, has a history of having a 9mm, and there were 9mm shell casings found outside of the home, that would at least tend to lead to the conclusion or support the conclusion that Jahlin may have the opportunity to have used self-defense, which would have made those convictions relevant and at least admissible to the jury. And so, at least for those positions, Jahlin would ask this court for a new trial based upon the exclusion of the evidence. As far as the manifest weight and sufficiency, again, he was convicted of complicity. And logically, how is one complicit in discharging a firearm? There was no evidence presented at trial that Jahlin provided a firearm, loaded the firearm, took any overt action where he loaded the firearm, helped somebody pull the trigger of the firearm, or anything else like that. So to aid and abet someone, which is what complicity is, the confusion that Jahlin has would be, how does one aid and abet the discharge of a firearm? Because that is the predicate offense of what he was convicted of. It's improper discharging into a habitation, and you have to discharge the firearm. So that's very, very important. So obviously, that's why Jahlin believes that the manifest weight and the sufficiency, the evidence presented at trial was not sufficient based upon that. And again, there were no shell casings found inside the vehicle, and Jahlin was identified as one of the occupants of inside the vehicle. So that's very important as well.
Counsel, I want to make sure I'm clear.
Sure.
You indicated he was convicted for complicity, but I thought, and maybe I'm just remembering incorrectly, was the indictment as a principal offender?
The indictment was not as a principal offender. The government proceeded on a complicity case, and the jury was instructed as such. In fact, trial counsel included in their closing arguments, I don't have the exact page cite, they were reading the definition of aid and abet, which goes to the complicity statute.
Well, obviously you can convict under either one. You don't have to charge, for both. So that's why I was just trying to. So nobody instructed the jury in regard to principal offender.
Correct. My recollection is that the principal offender was not. This was just, the jury was charged on complicity.
Thank you.
Sure. And so as far as the, again, and then the other thing about the jury instruction was Jahlin, the court instructed the jury about fleeing and eluding instruction, and that was provided to the jury there. Jahlin's jail calls were also admitted at his trial. There were evidence that he made some statements, and part of those statements were that he was worried that the police were going to shoot him. And so when the jury is instructed about fleeing, it is a consciousness of guilt. Here, there is evidence presented that he may have been running from gunfire. And running from gunfire is not a consciousness of guilt, that's self-preservation. And that was presented at trial. And again, Jahlin's jail calls admitted through transcripts at 435, 436 indicated that he was afraid that the police were going to shoot him. So as far as the instruction to the jury that he was fleeing and it was consciousness of guilt, there was an innocent explanation here. And the evidence at trial was there was shooting going on, there were shell casings found outside of the vehicle, there were shell casings found outside of the home, and Jahlin ran. And that was demonstrated at trial. So as far as the instruction for fleeing and eluding, again, Jahlin objected, and that is in the trials. Trial counsel did object to that instruction being given, so they did preserve that error for this court to review. So with that being said, given the evidence presented, Jahlin would ask this court to reverse his convictions because they were insufficient as a matter of law. Then in addition, if this court was not willing to do so, the instruction to the jury and the denial, or excuse me, the exclusion of the admissions that were proffered by Jahlin was an abuse of discretion by the trial court, and this court should order a new trial for Jahlin with the instructions that that evidence be able to be presented by Jahlin at another jury trial. And if the panel does not have any, there were two appeals of this. Jahlin is not contesting the case where he pled guilty, so that's also in the record. But if the panel does not have any other questions, then Jahlin will reserve his time for rebuttal.
Hearing none, you'll have your full 5 minutes for rebuttal.
Thank you.
Good morning. May it please the court, Helen DiMartino on behalf of the state of Ohio, the appellee. We're asking that this court affirm Mr. Suggs' convictions for improperly discharging a firearm into a habitation and discharging the firearm on or near prohibited premises. The indictment in this case did not charge just based on complicity. It indicates that in 2000, in the co-defendant case, which is 2022-01-0236B, it says, we do find and present that it lists all 4 defendants did commit the crime of improper discharging into a habitation and that they knowingly, without privilege, discharge a firearm into an occupied structure. And then it lists the penalty for that. So he was charged as a principal. Certainly there was an instruction given with regard to complicity and aiding and abetting. With regard to the evidence that was presented at trial, the testimony was that the officers heard gunshots. They went into the area of the street where they found this vehicle with smoke, plume of smoke over it, the smell of gunshot powder. Two men were entering the front seat, the passenger and the driver, and then there were two men standing outside the vehicle, dressed all in black, wearing masks, holding long guns. One of those men, after they got into the vehicle and subsequently fled and was apprehended, was Mr. Suggs. So Mr. Suggs was seen holding a firearm, he was seen outside the vehicle, and then he was apprehended after he fled. So there is sufficient evidence that Mr. Suggs had a firearm, he was present at the scene where gunshots were fired, and whether he was the principal offender or he was aiding and abetting, there's ample evidence that he knew what was going on that day. You have 4 men in a vehicle, one was a minor, but 4 males, 2 in body armor, all dressed in black. Mr. Suggs is outside all in black with that gun and the mask, and like I said, 5 separate guns are found in that car. This is not a situation where Mr. Suggs got into a vehicle and had no idea what was going to happen. There's absolutely nothing in the record to suggest that he had no part in what was going on. With regard, there was sufficient evidence to convict him, and the manifest weight of the evidence also to convict him. With regard to the self-defense issue, the testimony was that the officers hear the gunshot, they see the vehicle. As they put the lights on and they go to talk to the folks in the car, another set of gunshots break out. Mr. Suggs at that time is in the vehicle. He chooses at that time to get out and to run along with the other backseat passenger. So there's no evidence that he was acting in self-defense when the gunshots were fired prior to the second volley. And certainly the fleeing was because he wanted to get away from the police. The testimony was that the police were coming to the vehicle, and that's where the backseat passengers went. Even if Mr. Suggs was afraid that he might get shot, which he said on the jail call, he was afraid that the police might shoot him if he had his weapon. The evidence was that he didn't have the weapon. He left it in the vehicle. And the evidence also on the jail calls was that he said the police came when we were shooting. I understand that opposing counsel wants to refer to it as the royal we, but in fact, this is a defendant on a jail call explaining why he left his gun behind. There's no reason or evidence he was using the royal we. He was speaking of him and his co-defendants who had actually been involved in a shooting that the police happened to be in the immediate area of and approached right after it happened, quick enough to be able to smell the gunpowder and to see the plume of smoke over the vehicle. So with regard to the arguments that were made, there is sufficient evidence to support these convictions. The manifest weight of the evidence supports the convictions. The indictment was based on these charges. There was an instruction as well for complicity, as there usually is in these cases. With regard to the issue of these convictions that counsel argues was an abuse of discretion to exclude them, they have no relevancy as to the issue of whether or not Mr. Suggs discharged a firearm that day. The fact that a victim in the shooting may or may not have a tendency to carry a gun doesn't mean that he had a gun that day, doesn't mean that he shot that day, and even if he did, that has absolutely no relevance as to whether or not Mr. Suggs fired his weapon that day. Certainly the conviction for the victim the conviction that happened after this offense, that has no relevancy to what happened on this day. The co-defendant, the juvenile's conviction with regard to his involvement on this day has nothing to do with Mr. Suggs either, because the co-defendant could have pled as a principal or as being complicit. That has no impact on whether or not Mr. Suggs discharged a firearm that day. So it was not an abuse of discretion to keep this out, even with the very low standard of relevancy. In this case, there's no evidence that any of those 3 documents that Mr. Suggs wanted to have introduced into the record were relevant at all. And even if they were relevant, and the court erred in keeping it out, it would be harmless error, because the overwhelming evidence in this case was that where police arrived on scene and saw Mr. Suggs standing next to a vehicle with a plume of smoke in the odor of gunshot, holding a rifle. Then they saw him flee out of the car, leaving the rifle behind, in an area that's riddled with casings from the rifle, and at least one of the rifles, and from the 9mm. And in the manner that they were dressed, what they were doing, the number of vehicles that were found, the number of weapons that were found in the car, it shows beyond a reasonable doubt that all four of those individuals in that vehicle that day knew what they were doing, where they were going, and what they were going to do when they got there. At least one of the officers testified this was the first time he's ever encountered men in a vehicle wearing body armor, like the two in the front seat were. So based on the evidence that was presented at trial, the state would ask that this court affirm Mr. Suggs' conviction, and if there are no questions, I will rest on my brief.
Hearing none, thank you very much, counsel.
Thank you.
Thank you, Your Honors. May it please the court. On the rebuttal, Jahlin would again indicate that as far as harmless error is concerned, as indicated by trial counsel, a lot of circumstantial evidence, the physical evidence as far as the shell casings from the house, the shell casings outside of the vehicle, the fleeing, there was, as indicated, that Jahlin was fleeing from gunshots. And that instruction is fraught with problems because if you're fleeing from gunshots and you're guilty, you're trying to save your life. And so it would be hard for me to believe that the law would require someone to not flee just to avoid not getting the instruction when gunshot fire was at play. And I think that is an error to instruct the jury as such, and that does warrant a new trial given Jahlin's circumstances. And if the panel does not have any other questions, Jahlin certainly thanks this court for its time and would ask to reverse his convictions, and in the alternative, if this court was not willing to do so, order a new trial with the evidence to be admitted. Thank you.
Thank you very much, counsel.
Thank you.
Thank you both for your presentations. The court will take the matter under advisement, issue a decision in due course. The clerk of courts will mail a copy of the decision to you on the day it's released, and it will also be posted on the Ohio Supreme Court website.